Hello, I'm Keith Jones. I'm recording this video from historic Hillsborough, North Carolina, on the site where some of the leadership of the North Carolina regulators were hanged following their trial for their part in the Battle of Alamance. I want to talk to you about the 10th Amendment to the United States Constitution. The Constitution delegates powers to the federal union, but the first 10 amendments, known as the Bill of Rights, prescribes individual protections to the people from this union of states. They are often misunderstood and mischaracterized, and the fact that agents of the federal union have spent much of our history trying to find loopholes around the Bill of Rights is stark testimony as to why some people like Patrick Henry were so adamant that it was necessary. The 10th Amendment is in many ways the capstone of not only the Bill of Rights, but of the Constitution itself. It provides a summary statement of how the Constitution is to function and to be interpreted. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people, unquote. That's the 10th Amendment. St. George Tucker was one of the leading legal scholars of early America. He said this. He said, "Its language is very clear and distinct and has great pertinency." Tucker outlines the meaning this way. The United States possesses powers by delegation from the Constitution. Except those so delegated, the United States have no power. They have none by original or inherent intent, but only as delegated by grant, unquote. This means that if the Constitution does not say that the federal government may do something, then the federal Congress, the executive branch, or any of their agents have neither the right nor the authority to do so. And this is a key statement. Now, Tucker continues on to the states' right angle. The states have by reservation all powers not so delegated to the United States, unless prohibited to the states. So the United States federal government is not explicitly granted a power from the Constitution, meaning that if it doesn't say it, they can't do it. Then it is the right and the authority of the individual states to act on it, unless the states are expressly prohibited from such actions. Well, this takes us into the realm of individual rights. Tucker defines the people as being the people of the states. However, since the earlier amendments are perhaps the only portions of the Constitution addressing the rights of the individual, it would go to reason that this falls within the prohibitions against the power of states and the rights of the individual. So at the same time, the 10th Amendment both empowers the states and restricts them against enacting certain laws that would infringe on the rights of the individuals. The Heller and McDonald cases in the Supreme Court in recent years surrounding the Second Amendment would seem to back up this assertion. They assert that the Second Amendment is an individual right. Modern legal scholars assert that the 10th Amendment has been irrelevant since the New Deal due to federal spending programs. University of Texas law professor Lucas Poe says that it hasn't been taken seriously as a legal matter for 70 years. And he asserts that any federal law that taxes, spends, or regulates commerce proves that it is irrelevant. Of course, this is like asserting the cases where someone has gotten away with murder or theft proves that laws prohibiting these acts are now null and void. In many ways, the 10th Amendment may be the most powerful one sentence in the entire United States Constitution. Thank you for listening.